Welcome to Michigan Condo Voices, where real co-owners and real Michigan communities come together. We break down the issues that matter most with clarity and transparency. Let's get into today's episode.
Hi everyone, this is Stephanie with Michigan Condo Voices. One question comes up again and again in Michigan condo communities, especially during conflict. Can co-owners put their dues into escrow instead of paying the association directly? It's an understandable question, particularly when co-owners are worried about transparency, mismanagement, or deferred maintenance. But the legal answer is more nuanced than many people realize. Today, we're going to walk through when escrow may be allowed, when it is not, the risk involved, and why escrow does not automatically solve maintenance or governance problems. This is an educational overview, not legal advice, but it will help you ask better questions and avoid unintended consequences. When people talk about escrowing dues, they usually mean paying assessments into a separate account, often held by a third party or directly by the court, instead of paying the association directly. Here's the key points many co-owners don't realize. In Michigan, placing dues into escrow on your own is generally treated as non-payment, unless there is a court order or explicit authorization in your governing documents. The association may still consider the dues unpaid, even if the money exists elsewhere. Intent matters morally, but process matters legally. There are a few narrow situations where escrowing dues may be allowed. A court order. A judge may authorize dues to be paid into escrow during an active legal dispute, such as refusal to provide financial records, disputed use of funds, or a request for judicial oversight while claims are resolved. This requires a filed legal action, proper motions, and court approval. A co-owner cannot self-authorize this. Governing documents. Some associations may have language allowing alternative payment arrangements during disputes, but this is uncommon and must be explicit. If it's not clearly written, it does not exist. If dues are withheld or escrowed without approval, the association may still pursue late fees and interest, attorney involvement, collection actions, liens against the unit, and, in serious cases, foreclosure proceedings. Even when funds are set aside, enforcement can continue. This is why escrow is not a safe workaround for unresolved governance concerns. Here are some potential benefits only if court authorized. Escrowing protects funds during litigation, prevents immediate delinquency, and creates judicial oversight. On the flip side, there are risks and limitations. High legal threshold, expensive to pursue, does not reduce obligations, does not guarantee repairs, and it may escalate conflict instead of resolving it. Escrow is a legal tool, not a governance solution. Many co-owners consider escrow because maintenance isn't happening. But here's the hard truth, co-owners. Withholding dues does not compel maintenance. Deferred maintenance is addressed through governance processes, records access, board accountability, special meetings, elections, or court enforcement. Escrow does not automatically force repairs and can sometimes worsen conditions if funds become restricted without authority. The key takeaway for co-owners: dues generally must be paid as assessed. Escrow requires legal authorization. Withholding funds without approval carries risk. Maintenance and transparency issues require procedural solutions. Understanding the difference between financial protests and legal process protects your rights and your investment. Take care, everyone, and thanks for listening.